And then,
Now, this is a sensitive time, this service of process. That's
right.
when the respondent, the person being sued, first becomes aware of the case. Now, if you got a couple that's still living together and the process server comes to the door to serve one of the parties, you could have an incident right there based on this filing.
That's true, and it's also problematic when you have a situation where the person is living at they're living in the same house or same apartment, is that, and I've seen this on occasion, where the process server will come and serve the petitioner by what they call substitute service. You can serve by various different ways. One is personal service, where they give you the summons and the petition for dissolution. Another is substitute, where they can serve anybody that is 13 years of age or older. And then they also have to send a hard copy via mail to you as well. Or you could serve by publication. There are other ramifications with respect to that, but when you have a substitute service situation, and again, if it's the petitioner who's been served, there's been some instances where the petitioner doesn't say anything and doesn't let the respondent, the other spouse, know that they've been served, and so then time goes on, and then they get a default judgment, and that gets a little hairy. I really try to stay away. Really try to either make sure that the respondent gets served himself, or that he gets served at work or something. I hate to do that at work, but this way it gets rid of all the problems.
To give a real life example here, we have a case pending right now, names to be silent on, but the respondent, the husband, was served at his place of employment. Now the couple is still living together. Well, the husband got served, and he hasn't said a word to the spouse, they're living together now, that he was served. His demeanor hasn't changed. He's the same guy in the house. He's really playing coy. But as you know, and you're going to advise everybody right now, that person has 30 days from the date in which he or she is served to file an appearance with the clerk of the court, or they can be held in default, right? Is that the next step?
That is an appearance and an answer to the petition for dissolution,
well, definitely an appearance.
Or respond. Definitely an appearance, and there's going to generally be a fee. If it's a situation where you can pass the threshold and do what they call a pauper's petition, I think it's a 298 petition where they waive the fee. It depends on which county you're at.
Yeah, don't plan on getting the fees waived.
Some counties are better. Well, it just depends on your financial situation. If you own a house and there's equity, probably not, but at least that's available, and that's the first thing. The first thing you need to do is to really talk to somebody who does domestic relation. You need a domestic relations attorney, somebody who has done that for a long time and who is aware of the ramifications and the laws. And it's really nice to have somebody who is aware and familiar with the judges in the specific county.
So don't go to a guy who did the real estate closing on the house, or the guy who handled your son's traffic ticket or criminal case. You want someone who's experienced in divorce and family law.
Right. And there are people who do general practice and who do a large volume of domestic relation too. I mean, that's okay. But again, you want to make sure that they're doing more than a couple cases a year, that they're familiar with that. And again, the clock starts ticking. I get so many people that give me a holler and give me a call, want to set up an appointment. When were you served? Almost 30 days ago. And it's really difficult because, ignoring it is not going to make it go away. You have to deal with it. You have to face it head on. And again, as you said, you got to file your appearance, and then you have to respond to it, whether or not that's an answer to the specific allegations. And it's got to be tit for tat. Paragraph 1, admit or deny, or kind of plead lack of knowledge and say, hey, listen, you know what, I can't admit it or deny it. I don't have enough information, so I can't do either. Because it's very important. The rules say that if you don't do that for each and every one, all right, anything that's not specifically denied is admitted, any allegation. Now, you could also file what they call a motion to dismiss if the petition for dissolution of marriage doesn't have the proper allegations as required by statute.
Aren't you really prolonging the inevitable?
You are.
Don't you want to get involved in the case
You do.
And get it to a point where we can start resolving some of these issues?